This is the hearing for Deschutes County file numbers 247, 25, 537 PA, and 538 ZC. My name is Tommy Brooks, and I am the hearings officer in this matter. Please note there are two separate hearings scheduled for today. At this point, we are beginning with the hearing only for Deschutes County files number 537 PA and 538 ZC. If your interest is in the other application, which is file numbers 26-120 PA and 121 ZC, you will need to wait until that hearing starts, which will be right after this hearing. And if you are online, there's a separate Zoom link for that second hearing. Before we turn to the substance of this particular hearing, I'm going to turn things over to Ms. House to describe how the participation process works.
All right, thank you, Hearings Officer Brooks. For the record, my name is Caroline House, and I'm a senior planner with the Deschutes County Planning Division. The item, as the hearings officer just noted before him today, is a comprehensive plan amendment and zone change with the file numbers identified on the screen. So I'll begin by going over how the hearing will be conducted today and how to testify. I'll then provide a brief staff report. We'll then move on to the testimony portion of the hearing. The applicant will testify first and will have 30 minutes. Then those in support will have 3 minutes. And then anyone in opposition will have 3 minutes. After that, the applicant will have an opportunity to provide rebuttal testimony and they'll have 10 minutes. And lastly, staff can make closing comments. And I do want to note that the hearings officer can change or modify those time limits at his discretion. So if you're testifying at today's hearing, it's a hybrid hearing, so both in-person and remote participation is allowed. Regardless of how you testify, before you begin, please provide your name and mailing address so we can add that to the record and make sure you're included on our mailing list. For our in-person participants, if you haven't already, please make sure you have signed your name in on the sheet that's over by the door, and make sure you've signed the correct sheet. So there's 2 hearings. This is the first hearing, so make sure you signed up on that particular sign-in sheet if you would like to testify in person. And I will be using that list to call up each person. Please make sure you come up to the table and speak into the microphone. Sometimes these microphones can be a little finicky, so you might be asked to speak up, and that's just because, the microphones aren't always good at picking up audio. And let's see, for our remote participants, you must be logged in using Zoom if you want to testify. And Hearings Officer Brooks will ask you to use the raise hand feature to notify him that you would like to testify. If you're on a computer or smartphone, that will be done by pressing the raise hand button that's in the bottom center part of the screen. And if you've dialed in, you'll need to dial *9 on your keypad. In addition to oral testimony today, you can submit written testimony. Please hand that to me if you're attending in person. And if you're attending remotely, you'll need to email that to me. And I do want to note, I think there was some type of form letter that was generated that misspelled my name. My name is spelled CAROLINE.House, HOUSE, at deschutes.org. So if you're emailing, just make sure you have my name spelled correctly. Otherwise, I will not receive any electronic submittals. Staff and the hearings officer are responsible for an orderly and respectful hearing. If you're being disruptive, you may be asked to leave. And I'm going to pause now and ask if there are any objections to the hearing format described. All right, no objections. I'll turn this back to Hearings Officer Brooks for his hearing instructions.
All right, thank you, Ms. House. The process staff just described is the hearing procedure that's set forth in the county's code, and I will provide sufficient opportunity for everyone to participate at the appropriate time. And just ask for your patience as we go back and forth in the hybrid setting. This application is being considered through a quasi-judicial process. As such, I will consider only the factual evidence that is in the record, and I will then apply those facts to any relevant provisions of the county's comprehensive plan and its land use regulations. The standards and applicable criteria relevant to this hearing were identified in the public notice announcing the hearing. They're also set forth in the staff report, and the public notice and the staff report are posted on the county's website and available directly from staff upon request. It is important that you direct all of your testimony only to the standards and applicable criteria. If you believe a criterion applies that was not listed, you may address the unlisted criterion. However, I urge you to also explain why the criterion must apply and to do so with specificity so that other participants may respond and so that I can address that issue in my decision. As I mentioned, there are 2 hearings today. Some participants have already submitted comments to the record, and in doing so, they address both of those applications. It's my job to ensure that the record is clear for each of these applications and that I apply the unique facts of each record to the applicable criteria. When you are testifying, it is important to me and to the process that you address only this application that is the subject of this hearing, and do not assume that the comments you make are equally applicable to both applications that are scheduled for hearing today. If I can't tell which application you're addressing or which criteria you're speaking to, I will not be able to address your comments. The failure to raise an issue with enough detail that enables me or other participants to respond to the issue precludes your ability to appeal that issue to the Land Use Board of Appeals. Also, the failure to raise a constitutional or other issue relating to any proposed conditions of approval, again, with detail that allows me to respond to the issue, precludes an action for damages in circuit court. In my role as hearings officer, I serve as a neutral decision maker. Thus, while I have a contract with the county to serve in this role, I am obligated to remain impartial, and I do not represent the county's interests or the interests of any other participant. To that end, I'll state for the record that I do not have any relationship with the applicant, and I am not aware of any connections I may have to other participants in this proceeding that would prevent me from remaining impartial. I have communicated briefly with staff about the procedural aspects of today's hearing, but not the substance of the application. I do not have any ex parte context to disclose. At this point, I would like to figure out how many people we have signed up for testimony so that we can make sure we manage our time well. Ms. House, are you able to give us a thumbnail of that?
I'm just looking to see how many people. There's only 1 caller online, and there's 3 people that have signed up on the sign-in sheet. I think one of them is part of the applicant team. So it looks like the attendee online has their hand raised, so I assume they want to testify. And then, yeah, several people in the room.
Okay. Thank you. It sounds like we will be able to manage the time pretty well.
Sorry, Hearings Officer Brooks, there's a question. Okay, so yeah, there's some people that have not signed in yet, but will be testifying. So I guess probably 5 or so. Yeah.
Okay. All right, let's get everybody signed up. So based on that, before we begin, does anyone wish to challenge my ability to hear this matter or to challenge the county's jurisdiction over this matter? You can signal to Ms. House if you're in person, or if you're online, you can hit the raise hand function.
There is a raised hand online. I'm not sure if that person's hand is raised because they have an objection or if they raised it to provide or to let us know that they want to testify. If you are online and listening, can you dial *9 and take your hand down if you do not have an objection? But if you do, obviously keep your hand raised and don't dial *9. Okay, so they took their hand down. I think we're good. No objections.
Okay. So with that, I'm going to turn it over to staff to give the staff presentation.
Great. So I just have a few slides for today's hearing, just going over the subject property location. So it's assigned address 68621 Highway 20. The property is approximately 20 acres in size, and the owner and applicant is Willitts LLC. As has been previously described, the request is a comprehensive plan amendment and zone change. The plan amendment is to redesignate the property from agricultural to rural residential exception area, and the zone change is exclusive farm use to multiple use agricultural. And I do want to note that no exceptions to any statewide planning goals have been requested. My staff report has 2 potential issue areas that I'm going to highlight, at least for my oral staff report today, that staff is asking the hearings officer to focus his review. And the first is related to compliance with statewide planning goal 3, which is specific to agricultural lands. So staff is asking the hearings officer to confirm whether the property meets the definition of agricultural land under the applicable Oregon administrative rule. Staff is also asking whether the subject property is necessary to permit farm practices on nearby or adjacent agricultural lands. And in support of the application, the applicant has provided an Order 1 soil study and other detailed information to demonstrate that the property is not agricultural lands and is in compliance with Goal 3. The second potential issue area that I'm going to highlight is related to Goal 5, in this case related to designated scenic resources in Deschutes County. So a portion of the, not a portion, I should say the entire property, excuse me, is in an inventoried scenic Highway 20 landscape management roadway. And on the screen that's just a Google Earth view. I think that's dated 2018, showing what the view looks like, or it looked like at least that time. It was the clearer image, is why it's in my staff report. And the image on the right shows the boundary of the landscape management roadway, and the subject properties highlighted in red. So to demonstrate compliance with statewide planning goal 5, new uses that are allowed in the MUA 10 zone must be either you have to demonstrate that it doesn't conflict with the scenic resource or provide protections if that's necessary. So I just want to highlight currently conflicting uses are identified as development within the 1/4 mile overlay zone, which would excessively interfere with the scenic or natural appearance of the landscape as seen from the road, or alteration of existing landscape by removal of vegetative cover. So in support of the application, the applicant has submitted a new EC specific to the subject property and argues that all new MUA 10 uses are allowed because the existing Goal 5 protections are sufficient to protect that scenic resource. So all materials that have been received are published on the website that are shown on the screen. And I checked my inbox. I don't have anything new. So I think the record is completely current as it's currently published. But we'll do our best to upload everything. We're trying to get everything up within 24 hours, but recognizing that there have been a significant number of comments in the past week, but they're all published at this time. That concludes my staff report, but I'm available for any questions from the hearings officer.
Okay, thank you. I do not have any questions for staff at this time. So let's go ahead and proceed with the applicant giving its presentation.
Okay. Good afternoon, Hearings Officer Brooks. Chris Koback at 937 Northwest Newport, Suite 220, Bend 97703. I'm here on behalf of the applicant Willitts LLC, and Greg Willitts, one of the members, is sitting next to me on my left. And we're going to make a presentation. What I'm going to try to do is focus on kind of the critical issues that staff identified. I already submitted a letter to supplement our burden of proof, which is also fairly extensive, and then a supplemental letter that came between those two. That gives to the hearings officer most of the information we think that's relevant. I'm going to highlight some of that and focus on what I think is most important. I do anticipate there will be an open record period because we're going to request one. I saw a representative from Landwatch walk in a little while ago, so I'm pretty sure in about 20 minutes I'll be handed a letter that I haven't seen before, and we'll need time to evaluate that and respond in a 7-day written record period. So staff did a good job of introducing you to the property. It's a 20-acre parcel that butts up against the city. I explained this. I don't think it's overly significant, but this 20-acre parcel used to be part of a larger parcel, most of which is in the city. And there was this 2004 subdivision, and the importance of that is that's what created this as a legal lot. It was lot 16 on that subdivision, but it wasn't included in the city, and we're not suggesting that has any real significance on the criteria. The criteria still apply as if it's EFU land, because it is. But I wanted to explain that. The property has a long history. This is in one of our letters, anecdotally, although it was apparently used at one point, part of it, as a livery stable. And then when travelers started coming over the mountain in cars, there was a service station on the property because by the time they got over the mountain, invariably the older cars needed some attention. Since then, it's been part of a larger ranch that's been broken up for many, many years, the Lazy Z Ranch. And we highlighted what the Lazy Z Ranch is now. It's really a kind of a conglomerate of different uses. The city uses a lot of it for a wastewater treatment facility. Our neighbor, Mr. Jaros, you'll hear from him next. He's got the second application. Similar to us, there's no agricultural use on that property. It's dry, bad soils. It meets the criteria for a rezoning just like ours. Across the street, there's a nature preserve, and I think the owners of that are here. They've done a wonderful job of rehabilitating an old farm that had kind of, from what I understand from the newspaper articles, had kind of degraded the property. They've made it into a beautiful nature preserve, and that's what it's being used for now. There's some farming activities across the street as well. Soils are a little better there. There's a meteorary, I think that's how you pronounce it. It makes that thing, that drink that's called mead that you might see like in the old English movies. And it's made with bee pollen, so there's some pollination going on over there. The tasting room is over there. I think they do some wine events. And then down the road, there's some more pasture land and hay growing. And so that's kind of the neighborhood that the property is in. The main criteria that we have to address, the county criteria is in Chapter 18-136. And the first question is more of a legal question. That's is the public interest best served by rezoning? And you consider some factors. All I want to point out here is a hearings officer recently interpreted that provision to mean that if you meet those factors, those four factors, A, B, C, D, that you do satisfy that public best interest test. That's how you have to interpret it. And that interpretation was challenged in the lower level. That case is on appeal, but the issue over that interpretation was never appealed. So I'm going to submit that that's an interpretation you can and should apply to 18-136-020. And then walking through that, the first one is you have to establish consistency with the comp plan at some level. We've done that in detail on all three of those documents that I referenced. And the main one I want to talk about today is the policies in, I think it's Chapter 2, preserving agricultural land. And that kind of gets us to the whole core issue that staff raised is this agricultural land? And at this point, I'm going to segue into the kind of the state regulations because they're the best definition of an ag land. And you start with, I'm not going to, we've recited the provision, the administrative rule in our written material, but it starts out by saying land that's Class 6 or better. That, if you look at the NCRS surveys, if the soil is predominantly Class 1 through 6, that's defined as agricultural land. If it's higher than that, which is kind of counterintuitive, 7 and 8, which is worse, then it's not agricultural land. And we've established that with two things. The maps support us. If you just look at the maps, the predominant soil, all the soil is 47 something, and that's not generally an ag land. But then we had that supplemented with Mr. Kitzrow. He did the one on the application you're going to hear on next too. He's very reputable. He does a lot of these. He did his on-site test, and he came up with our soils being just shy of 70% Class 7 and 8. And I'm not going to get into all the scientific lingo about it, but it's recited in our material. The main problems with this soil is it's rocky, it's void of any soil fertility, and most important, it has no water holding capabilities, the capacity to hold water. I think they look at less than 2 inches being really, really bad, and that's mostly what we have is very, very poor soil with low water holding capacity. So we passed the first test, I think, and I don't think anybody's really disagreeing with that. The next one is the one you hear a lot about, and I know in some of the cases you've heard lately, this has come up in a lot of the LUBA cases. it asks you the question of whether land that's not farmland under the statutory definition, it's not 1 through 6, is it still suitable for farm use considering certain factors? And it's important to note that the test is not just whether it's suitable for farming in the theoretical. You can't just rely on conjecture. You really do have to apply these factors. And they're similar to what you would look at to define what Mr. Kitzrow would look at. You look at soil fertility, you look at suitability for grazing, you look at climate issues, availability of water, future availability of water, you look at technology, existing land use patterns. And so when you apply those, the question then is it still, this bad soil, is it still suitable for farm use? And what we've kind of explained to you, and Mr. Kitzrow has as well, is these core fundamental qualities that you need to engage in farming. You need soil fertility, you need water holding capacity. You need these intrinsic soil values to start. And then we looked at, could it be used in conjunction with other lands? Well, you're going to hear the Jaros property next to us. It's as infertile as our property, and it doesn't have water. And so that, not only are we not suitable alone, we're not suitable with his property. And so we also looked at whether the city property was an option. Are we a part of that farm unit, I guess, as part of the regulation. But the city's property is interesting because, as I said, they use it for some of it for irrigating wastewater. And then they do lease some of it to the Black Butte Ranch, I understand, for some horse grazing. But the city gentleman sent a letter in this week saying they're definitely going to be sprinkling that with wastewater in the future. So that use is ending. And that's a big hundreds of acres. It will be. And I've given you the Lux that the city sent in 2016 for their application. And it's got a really important document. It's the document they prepared that explains what you can and can't do on the property that they sprinkle. And it's telling you can't use it for anything. At one point, it says you have to haul off the material that you grow and dispose of it. You have to fence it off. You can't sprinkle if there's school children nearby. And so our position is, the city's basically taken their land now and in the future and made it a commercial use or a public facility use, I guess. And in fact, that document does say that from the city's consultant, it does say that before they start using this future expansion area, the stuff right next to the Jaros property, that they're going to rezone it PF, which would be then a city public facility zone, which is what the city did for the main plant about 2008. So when you look at that property, this is all on the south side, there's just no way you could do any farm activities supported by those factors, right? Now you'll hear perhaps, because we've heard it before, that there's maybe some theoretical farm activity you could do on that property. But what you're not going to hear is any detail on how that would be done. And it's important to remember that LUBA has clarified that farm use, you look at the objective test as whether a reasonable farmer would be motivated primarily by the pursuit of a profit through money by pursuing one of these activities. And so, profitability alone is not the test, but LUBA has confirmed recently, and I've cited these cases, profitability is something that has to be considered along with the cost of producing something or engaging in activity, because this objective test asks you, what would a reasonable farmer consider? Well, we would submit that a reasonable farmer is going to consider cost to acquire the land, cost to hold the land, cost to prepare the land, build your buildings, everything else you've got to do, and then what can you make out of it? And considering all of those factors, are you going to be motivated to take this 20-acre fallow property with limited water, bad soils, a lot of rock that you'd have to remove, and are you going to try to pursue any kind of agricultural activity? We would submit you wouldn't. And so that test has been met. The newest issue that has come up is this subparagraph C in the administrative rule, and that's is our property necessary to allow farm practices on nearby lands? And I know that was recently discussed in a couple of LUBA cases, and it's come down to whether or not our land would be useful for somebody else, as I interpret it, or whether it's necessary to keep our land EFU to protect and allow farming on other properties. And I just explained on the south side why that you just can't be, that can't be the case. There is no farm use on the south side, the south side of Highway 20, where we and the Jaros property is located. It's the city sprinkling, it's us. There's some forest land beyond us. To the south, there's the main public facility. So our property certainly isn't necessary to be part of any farming operation, and there would be nothing impactful of an MUA 10 use on our property that would necessarily limit or interfere with anything on those properties because there is no farm use. There's no farm practice. As to the north, we're separated by Highway 20. And there's an application that on a property over there in 247-22-00024 CU and a bunch of other numbers. We'll submit this during the open record period. Well, the Board of Commissioners actually did this analysis because when the owner did that mead tasting room as a commercial activity in conjunction with farm use, they had to show the lack of impacts of that use on all of the surrounding properties. And they've got a whole chart in here that they looked at every property in the area, both sides of the road, and the county board agreed with them that use, that commercial use, would not generate any impacts that would negatively affect what's going on in the surrounding properties. And in my view, that kind of settles that question. If the board has already agreed that this commercial activity that's going to generate traffic and all of this other stuff that comes with it isn't going to have a significant negative impact on the ongoing use of the farm properties in the area, well, then a limited rural use that would be allowed on MUA 10, we would submit can't have any greater impacts, probably less. So we don't think it's necessary to keep our land zoned EFU to permit farming on the properties to the north, any kind of farm practice. And so that handles kind of what we think is the first core issue. Is this agricultural land? Once you get to that conclusion and you apply the county goals, they're really consistent with this application. It's preserve farm agricultural land. Well, it's not agricultural land. So we qualify for that. Rural growth is section 3. We handled that. We've explained how the transportation system works and checked off all those boxes. So the next issue that I think is important to talk about is goal 5. And this is another one of those issues I think you'll agree is kind of a newer issue. I think it came up in a case you heard, and then LUBA decided that applicants can no longer rely on the 1992 Goal 5 program to establish alone that Goal 5, your proposed rezoning is consistent with Goal 5. And as I read the cases and the local decisions, it's because LUBA reasoned that you're allowing new uses under MUA 10 that weren't on the subject property in 1992. So at a minimum, I think what LUBA is saying is you got to look at whether these new uses that are allowed under your new zone would create some, I wrote it down what staff said, substantial interference with the purpose for this Goal 5 scenic resource. And what applicants have done is we've prepared now, both Mr. Jaros and we did it, and I've done it in a couple other cases before this, and I think other people have done it, is we're preparing these site-specific ESEE analysis to establish that there are, we identify the potential conflicting uses, and then we kind of explain how allowing those uses wouldn't create a substantial interference with the Goal 5 purposes. And the regulations, I think, allow that. They say it has to be doesn't have to be complex or long. Basically, the only guidance you have. So, and I think most people are kind of following the same format. We identify all the uses and we identify the potential conflicts and benefits from allowing the uses or not allowing the uses. And then the next question is, what do you do with that inventory? So you've got this ESEE and it identifies all these conflicting uses, and what does the county do with it? Well, what I submit is we don't need any new program. The current program is already in place, and it works well, and it accommodates exactly what we're asking for, MUA 10. I noticed, I did some research the other day, and there is MUA 10 and RR 10 property within the same scenic corridor on Highway 20. And so I would submit that the county's already shown and established that within the LM zone, this scenic zone, the uses allowed in MUA 10 and RR10 are permitted. You can do it. You've just got to comply with the LM standards. And I recited this. I was at one of these hearings a while ago, and Will Groves, the planning manager, testified. And he explained that, the purpose of the LM zone isn't to prohibit development. It's really to ensure compatibility of development. And so I gave you 3 examples of LM cases in the past in the same corridor that were involving slightly different zones. One was for a property that was EFU, and it was the use proposed was a non-farm dwelling. And so the county applied the same standards and found compatibility with the Goal 5 resource. And then I gave you an RR5 LM decision where it was similar analysis, looked at the uses permitted under that zone, and then it applied the substantive standards and found compatibility. And then I gave you one in MUA 10, same scenic resource, same process. And I would submit that when you look at those cases and how they're processed and you put them in the context of the LM zone and the Goal 5 inventory, I think you'll agree with me that the program we have now is the only program we need. What you need to do is exactly what we did. Provide the new EE analysis chart, and then you have to determine, can the specific uses, when proposed, can they be compatible if you apply the current program through the LM in Chapter 1884. So that's how we see Goal 5 being accommodated in this rezoning application. So with that, at this point, we're going to have an open record period. We'll have some rebuttal. Unless you have questions, I think we're going to let you have our written stuff with these comments, and we'll come back and rebuttal, and then we'll submit as necessary during the open record period.
Okay. Thank you, Mr. Kovac. I actually don't have any questions for you at the moment. I appreciate the presentation. Maybe that changes on rebuttal. We'll see.
Okay. Thank you.
So at this point, Caroline, if you can help me call up the first person who has testified in favor of the application, if there is one.
If you're attending in person and support, could you please raise your hand? All right, go ahead and come up.
Which mic is
Both of them are actually. Thank
you. Yeah, good afternoon. My name is Bruce Runglin. How do I know I'm talking to you? I guess, okay.
That's a good, you're looking right at me now.
All right, great. My wife and I are here. We're neighbors of these folks, and we're in favor of their application. The ranch land they're talking about, the old Lazy Z, was owned by my wife's family for 30 years as a 1,400-acre ranch that was referred to in the write-up. We think it's a good idea. The Willitts family has been a really prominent family in building the community of sisters over the last 20-some years. Built a theater complex, a sports club, took a lot of risks. Five Pine is a successful enterprise, and we think it'd be great to have it expanded. Finally, just for the record, the commentary against this says it's been a pristine farm area since the turn of the 20th century, and I'd like to just put the record that's just on this particular piece of property, there was a golf course in the 30s, and in a 9-hole golf course. So it's been used for many different purposes, apparently, over time. Anyway, my wife, Marlene, and I would like to see this property converted.
Thank you.
Derek Yaros, I think you had your hand up, right?
Good afternoon. My name is Derek Jaros.
You might need to talk a little bit closer to the mic.
Okay. Good afternoon. My name is Derek Jaros. My family and I own the property immediately to the south and the east of the Willitts property. Our property is 68589 Highway 20 in sisters. So I just want to say that I also am in favor of this rezoning. It is currently zoned ag. From our experience, you sure can't do ag things on it. We have tried in many cases to lease this property with failure because nobody wants to stay on it any more than their first year of trying. We, as the Willitts property, have no water rights, extremely poor soils, which we have just confirmed through Gary, the soil scientist, that are much worse than what we thought. Our soil tests are showing predominantly 7 and 8s also, which supports the Willitts. We have very similar geography there. And in short, we've attempted to just do short grazing on this with little success. Nobody wants to come back. I virtually have to pay them if I want them to come out and do it, and they'll still leave after a year. So I just want to state that in no way can these properties support agriculture. I'm sorry, it just doesn't work. No water, horrible soil, and the drainage, the soil just holds no water. It's just gone. And so now we're good at growing invasive species. We have lots of cheatgrass. We have lots of mustard. But to do something that's valuable for farming, I'm sorry, we can't do it. We've tried hard. And we have hired some of the, along with Bill in 2018, a regenerative farmer who has successfully in the area and internationally, he now works for a huge company in Australia, has rehabilitated farmland through seeding, special seeding and organic stuff into the soils. He tried this on our properties in 2019, and we had almost zero success. There was like zero germination on the Willitts property. And on ours, we had about a 10% germination on 2 acres of the property, none of which came up the second year. So we've gone to extraordinary lengths to try to increase the productivity and actually make it ag friendly. It just doesn't work. I'm in favor of their zoning request.
Thank you.
Is there anyone else in support of the application that would like to testify? All right, seeing no raised hands in the room or online.
All right, then let's move to anyone who signed up in opposition.
I think Carol.
Good afternoon, Hearings Officer Brooks and staff. My name is Carol Macbeth, and I'm a staff attorney for Central Oregon Land Watch, where our address is 2843 Northwest Lolo Drive in Bend at zip code 97703. There are multiple reasons that the proposal violates the applicable law. Among them, the property violates Goal 3. The property meets the definition of agricultural land under Goal 3. It was historically part of the 1,400-acre Lazy Z Ranch, which started operating in 1885. And it's correctly designated as agricultural land right now as part of that historical farm unit. In addition, Land Watch has extensive evidence of the past farm use of this property, as contradictory to what you've heard earlier. The Oregon Legislature's agricultural land use policy requires the preservation of agricultural land in large blocks, and that policy protects the land against developers buying parcels of land and saying that they can't make a living on it. The policy is to protect it in large blocks, to keep it priced for farmland, so that young farmers can get into farming and that established farmers can expand their operations. In addition to violating Goal 3, therefore, the proposal is against public policy. Nor can the proposal be reconciled with Goal 5, the protections in place for scenic views of Deschutes County along all of its major roadways and its streams and rivers. The economy of Sisters and the region depends in great part on the scenic beauty of the region, and the county has protected its scenic views from its roadways, streams, and rivers. And this proposal for a property that is 100% within that Goal 5 1/4 mile is inconsistent with Goal 5. So on either side of Highway 20 coming into Sisters, the land is protected for a 1/4 mile distance from the center of the roadway. And this property at 20 acres is wholly within that Goal 5 corridor, and so can't be made to comply with Goal 5 as has been implemented by the county in its Goal 5 program. Moreover, the proposal would violate Goal 14, which restricts this type of development to inside urban growth boundaries. The citizens and City Council of Sisters have worked carefully to prepare for the next urban growth boundary expansion. This puts all that to naught. It's making a mockery of the public process in violation of Goal 1. All of these people have attended hearings and read things and expressed their opinions about where the urban growth boundary expansion should go, but the developer is unconcerned with that and wants to have his own special dispensation. This, again, is against public policy, and the proposal itself cannot be made consistent with Goal 14. Moreover, the Deschutes County Comprehensive Plan Policy 3.3.1 imposes a minimum lot size requirement, and the proposed zone MUA is inconsistent with that lot size requirement because it allows smaller lots than the 10 acres required by the plan. I just wanted to close with two observations that although there may have been a golf course at some point in the past, our evidence shows that there's an extensive farmland history of the entire 20 acres, going back to at least the 1950s, according to the aerial records to the photographs that we've seen. And we ask the record to be held open 14 days. So far, there have been 322 comments in opposition to this application, and we want to make sure that everyone has an opportunity to look at what's being proposed and to make further comments if they'd like. So yeah, those are the points that we wanted to make this morning. If you have any questions, I'd be happy to answer them.
All right, thank you for your testimony.
Thank you.
Is there anyone else in the room that would like to testify in opposition? Okay.
Hi, I'm Teresa Kohler from Sisters, and I am opposed to the rezoning request submitted by Willitts LLC. I concur with the statements that were just shared by Central Oregon Land Watch, every one of them. The application would open the door for possible development of rural land outside of an urban growth boundary in violation of Goal 14. As mentioned, the community of Sisters just spent a multiple year-long process establishing our urban growth boundary expansion plans. Additionally, the possibility for utilizing this land for a small farming operation has not been adequately considered. In my opinion, what the applicant's report about regenerative efforts was limited. Regenerative efforts can take multiple years or decades to get to fruition. And I think that the productivity of farmlands by the very historical measure of soil, according to a rating of 1 through 6, okay, more than 6, not okay, is narrow in contrast to the many ways, the many locations in Oregon and beyond that have shown very big success with regenerative farming. Thank you very much.
Thank you.
Is there anyone else in the room that would like to testify in opposition? There's no one else in the room, but there is somebody online, I believe. Well, they just lowered their hand. Is there anyone online that would like to testify? You'll need to dial *9. Okay, we will promote you now to a panelist so you can testify. And you may have to dial, I believe it's *6 to unmute.
Hello.
We can hear you now.
Oh, good. My name is Shannon Falk, and I am a member of the Willitts LLC, and I stand with Teresa Cole and everyone opposed to the Willitts LLC. This is to remain as part of the agricultural preserve. There should be no development, no room for development, no window for development, and it is wrong. And I am here to say, as a member of Willitts LLC, I am ashamed of what they have done, and I hope that they willingly withdraw. Thank you.
Thank you for your comments.
So there's no one else online or in person to testify.
Okay. Mr. Kovac, do you want to come back up for a rebuttal?
Thank you, Hearings Officer Brooks. Chris Kovac again. Very briefly, the comments on the current urban growth boundary expansion are irrelevant. There's nothing in this request that seeks to include this property in the urban growth boundary. It is simply to apply a new county zone to the property. So I think that's just not relevant to the discussion. Similarly, 3.31 of the comp plan, not relevant. We're not asking for any parcels less than 10 acres. There's no inconsistency in this quasi-judicial application. There's other cases going on where the county's amending and there's been facial challenges. That's not before you. And again, I don't think it's relevant to this application. It does not seek any approval inconsistent with 3.31. I think that's it. The last comments, I don't know what to say other than the old phrase, you can't pick your family. It's unfortunate that we have somebody that's there. She's not authorized to speak for the applicant. So unless you have questions, I think that's all we have.
Okay, thank you.
And that's the 7 day. I do want to comment, if this is my last chance, we don't think 14 days is needed. There were a lot of comments, but if you look at them like we did and inventoried them, I'm thinking 90% of them are a form letter that's Landwatch prepared and sent out to people all over. I found letters in response from the Valley, people that probably don't even know where the property is. So, and the fact that none of them testified today shows me I don't think we need to add another 14 days for these people to not participate. So we would just like you to stick to the 777 traditional period that's provided for in the statute. Thanks.
Okay, thank you. And I don't have any further questions for you. I do want to know if staff has any final comments, and of course, if it's substantive, I'll let the applicant speak again. But Ms. House, is there anything staff needs to state for the record?
No, just clarity on the open record, staff supportive of the 777 recommended by the applicant.
Okay. That sounds good. So I think that is what we'll do. I don't see any reason to veer from kind of the traditional time frame that seems to be pretty adequate in most cases. So we can leave the written record open for a 777 period, which, to remind everybody, it would be 7 days for all participants to submit evidence.
Hearings Officer Brooks, we do have a hand up in the room related, I think, to the open record period.
Okay.
Hello, Hearings Officer. It's Carol Macbeth again for Central Oregon Land Watch. If new materials have been submitted today that we haven't had a chance to see either, we do ask again for 14 days or perhaps 12 days in order to respond to whatever's been submitted today and to allow, again, there's been 322 comments. That means 322 people oppose this application, no matter what form they chose to show it in. And we would, again, ask for 14 days and hopefully at least more than 7 to take into account new information and to allow everyone to have a chance to participate. It could be hundreds more that would like to put in something. Thank you.
And the applicant might want to further clarify, but they have not provided any new materials today. They did submit materials yesterday, I believe, was the day that they, yeah. Okay.
Okay, thank you. Yeah, I appreciate the comment. I think the purpose of the post-hearing process is not necessarily to allow additional participants to come in, but really to let the existing participants refine the record as they've started to develop it. So I think I'm going to stick with my initial decision, which is to leave the written record open for the 777 period. I think that is sufficient time for anyone who's already participated to kind of either add to or refine what they've already put into the record or respond to what's already been put into the record. So with that, I think just as a reminder before Ms. House gives the instructions for how to do that, the first 7-day period is for all participants, and new evidence can be included. The second 7-day period is just for rebuttal evidence to respond to stuff that came in during the open record period. And then the final 7 days would be for the applicant only, legal argument, no new evidence to be supplied at that time. And at that point, the record will close. Ms. House, do you have the dates calculated for that?
Yes, I do. So I'm doing a share screen now. So just corresponding to the 3 periods that Hearings Officer Brooks just outlined, new evidence and testimony deadline will be Thursday, May 28th at 4 p.m. Rebuttal evidence and testimony, the deadline will be Thursday, June 4th at 4 p.m. And the final argument, which is an applicant-only submittal, the deadline will be June 11th at 4 p.m. I'll just go ahead and note on the record, I will be out of office on June 11th, but I will have my inbox monitored so that information's uploaded for the hearings officer's consideration. And then just a few other kind of technical notes about submittals. All submittals should be sent to myself, so Caroline House. And if you're going to email them, again, my email is Caroline, CAROLINE .house@deschutes.org. And anything you want to enter the record needs to actually be submitted. So links or just a link or hyperlink to a website or anything that's stored in a cloud storage system is not added to the record. And then the last thing, and this comes up every once in a while, is submittals need to be received by the county server by 4 p.m. And so just make sure you give yourself enough time and don't wait till the last minute.
Okay, thank you, Ms. House. So everyone has the instructions now for how to submit additional materials to the record and the dates that those materials are due. I'm going to close the hearing, but keep the written record open as I just described. And we will go off the record here at 1:57. I do want to note we're supposed to have the other hearing immediately after this. I'm going to take about 6 or 7 minutes to make some notes here before I log on. So it'll probably be about 2:05. But with that, we're off the record.